I know you thought you saw the last of this fool, but we have one more video to complete the trial, his restitution hearing, and of course, his appeal. Welcome back to the never-ending trial of Darrell Brooks, the Waukesha Parade attacker. Let's first jump forward to his restitution hearing in April of 2023.
We're here today to address the state's request for additional restitution. That letter was filed back on November 30th of 2022. The court had given Mr. Brooks until January 3 to file an objection, and a response was filed that the court interpreted as an objection. Since that time, Attorney Covey has been appointed to represent Mr. Brooks in the appellate process, but you are appearing here today, and we are thankful for that.
No words are more true. You know the court did not want to see another day of Brooks and his crap.
And so the matter was put on. Obviously, it's outside some of the time limits, but I would note the original request was made timely, and frankly, it was due to the court's calendar. Originally, I had been scheduled to be in a 5-week trial starting February 13th. And then that was delayed by 2 weeks, and ultimately that trial was adjourned. And so that was the reason for the hearing being scheduled on today's date. So for now, I don't anticipate your client having to talk. I can just hear background, so I'm just going to mute it, and if we need to talk to him, we'll unmute. There'll be a 30-second delay unless he has the device there, but to unmute. But in any event, I think I've accurately stated kind of the timing of the requests. As I understand, the additional paperwork that was filed as recently as April 12th, and I trust you've seen that, Attorney Covey?
Judge, yes, I did see, I think you're talking about document 566?
Yes.
I have that right in my hand.
All right, and so does the state have a grand total for additional restitution the state is seeking?
So to be clear, Your Honor, on the document, is that the one that's titled, well, the first thing is crime victim compensation? Okay, thank you.
Yes, I just couldn't tell if that, I didn't do the math, if that's...
Yes, I wanted to be clear on that. So at the bottom it notes you've already ordered sum of $124,220.65 to crime victim compensation.
Yes.
The grand total that's listed at the top of $134,466.85 encompasses that 124. So this is not in addition to, okay? So our request for crime victim compensation is $134,466.85. For Wilbur and Associates or Hartford Insurance, total request is $108,164.61. Optum Subrogation, $118,805.62. Progressive Insurance, $10,000 for victim GGG, and Progressive Insurance, $104,662.64 for victim Q.
All right, and I believe your letter of November 29 indicates the additional amounts that you're seeking. And then this document really totals things up.
Yes, it does. And at the bottom, already ordered the EMC insurance for Waukesha School District. That was already ordered, and there's no update to that number, so that number can remain as fixed.
I'm just going to do a quick calculation to determine the additional amount to crime victim compensation the state is seeking. Looks like that's $10,246.20.
I'm sorry, can you repeat that number?
Assuming I hit the keys on my calculator correctly, it's the difference between the 134 plus minus the 124, and that's $10,246.20.
Yes, we agree with that.
All right, and then the additional other amounts to other individuals, namely insurance companies, are really those four amounts that are listed in the, near the bottom of this document to Hartford Insurance, the Optum, and Progressive for two different victims.
Yes, correct.
All right, is that your understanding of what was being requested, Attorney Covey?
Judge, it clarifies things. I had thought that the state was asking for an additional, the full 134,466.85 in addition to the 124. So my number, original number, I thought was just north of 476,000, but it seems like it's closer to about 350,000, give or take. I'm using round numbers because I don't have a calculator with me.
Understood. It's my understanding from the document that you filed on behalf of Mr. Brooks that Mr. Brooks is not contesting the loss that was suffered, but rather his ability to pay.
Judge, that is correct. I'm not asking for, at least for anything to date, anybody to present extra documentation as to the accuracy of these numbers. It's just on his earning ability and lack of funds.
And was that the state's understanding as well?
Yes.
I know in the filing from Attorney Covey, I don't recall if it was the letter or the actual motion to deny, there's a claim that Mr. Brooks is indigent based upon his incarceration. Is the state going to take any issue with that?
We're agreeing to that fact, Your Honor. We've reached a stipulation with Attorney Covey that recognizes Mr. Brooks, to our knowledge, is indigent at this time and that his future earning capacity would be limited to prison wages.
Considering he never held a steady job, he was indigent before all of this.
And that's an agreeable stipulation to the defense?
Judge, we reached that agreement yesterday. Absolutely, I suggested it.
I don't want to be presumptuous, but I know the last time the court addressed restitution, the state was requesting really an order related to an escrow account. Should there be future payouts or earnings by Mr. Brooks, will you be making the same request?
Yes, and I noted that is in the original judgment of conviction that was filed by the court on November 17th of 2022. You had made that order and that finding at the time of sentencing, and you had also indicated restitution costs and surcharges and fees to be collected from prison monies pursuant to statutory authority. And so we're going to ask both of those orders remain in place.
Will your client have any objection to that?
If there's additional restitution, I don't object to the escrow account.
That would be for monies paid to Mr. Brooks, not a restitution, not an escrow account beyond that. Under 949-165.
I'm sorry, counsel, if I may, just for 1 second. Okay, thank you so much. Judge, counsel explained to me briefly what she was getting at. I don't have any objection to that.
All right. Then it seems to me there's really just some legal arguments as to whether I should order the additional restitution.
Yes, Judge.
The stipulation then would put us in a position where Mr. Brooks does not need to testify. That's my understanding, and that would be how I would proceed. Anyone see that any differently? Attorney Opper?
We do not.
Judge, that was the reason why I suggested the stipulation.
All right, thank you. Then, since it is the state's request for additional restitution, I'll hear from the state.
Thank you, Judge. Your Honor, we are asking this court to order restitution in the full amount as proposed in the document we filed yesterday. I think you said it was 566.
Yes, counsel. Here.
Thank you. I'm sorry. I just don't know the document number.
Yes, it is document number 566.
Judge, we certainly understand ability to pay as one of the factors that the court is to consider here, but we'd like to highlight a couple of things. First of all, one of the goals of restitution is to rehabilitate the defendant. We think that is an important goal in this case, noting the damage that was inflicted by this defendant to multiple victims. We would note that most of the monies, or at least a majority of the monies, came from the Crime Victim Compensation Fund, which really is funded by taxpayers. It's a state fund, and that I'm glad to see on this list there's no individual victims. That the desire for the public to have those monies repaid to the CVC if appropriate. As far as the insurance companies, the same, Your Honor. While I understand they operate as a for-profit business, these were substantial expenses that they had to cover for their insured, for their clients, and a direct result of the defendant's conduct and the significant injuries that several of these victims suffered as a result of Mr. Brooks' behavior. So we do believe that it's both fair and appropriate for the court to order the whole amount, notwithstanding that limitation. The reality is that perhaps this will never be achieved by Mr. Brooks in his lifetime on prison wages, but it would serve a rehabilitative purpose, because should he ever receive employment within the prison system and a wage, albeit minimum, it would be a reminder to him and aid in his rehabilitation that for whatever monies he earns in the prison, a portion of it does go back to the Crime Victim Compensation Fund. And the other thing is, Your Honor, of course, we don't know if an escrow account would ever be needed under 949.165, but I think we can make a reasonable observation here that there is potential for Mr. Brooks to obtain money in the form of payment to sell his story, to engage in a book deal or a movie offer or whatever it is. We know that this case garnered international attention. It's not beyond the realm of possibility that someone may at some point offer him some funds or some sum of money to share his perspective on this case. And so I would hate for this court to, set $100,000 today and then tomorrow he gets a $500,000 book deal. That would be offensive, I think, and go beyond the scope and the purpose of restitution. So for that reason, Your Honor, even noting his current limited ability to pay, we feel it's appropriate that you order the full amount as requested. Thank you.
Before I turn to the defense, I don't want to make any assumptions, but it's my recollection, probably during the sentencing, maybe even during some of the witnesses, or even during maybe discussion related to jury selection, obviously the community had set up a fund for victims to seek reimbursement. It's my understanding that this restitution amount that's being requested would be larger. I don't know if it would be substantially larger if all losses were being requested by the state.
That's an accurate statement, Your Honor, and I think it's very fair to say it would have been substantially larger if it not had been for the generosity of individuals who contributed to those funds.
As I recall, were there millions in that fund at one point?
I believe that's accurate, yes. I've confirmed that.
The United for Waukesha Community Fund, established by the Waukesha County Community Foundation and the United Way, raised over $6.4 million. The majority of the money was distributed directly to more than 560 individuals, including families of the deceased, the physically injured, and those present at the parade. I'll give you a minute to let that sink in. More than 560 people affected.
All right. And then I had also heard, but I don't know if there's any truth to this, but that at one point Mr. Brooks himself may have demanded payment to talk to a news organization or some media outlet. Again, I don't want to make assumptions, but I had heard that at one point.
Attorney Wichow and I are, I've heard that as well, but I can't confirm that with any certainty, Your Honor.
All right, thank you. Then turning to you, Attorney Covey.
Thank you, Judge. Although I'm relatively new to the case, I can state just from my review of the file so far, I haven't heard anything at all about anybody offering any kind of book deal or any kind of sums of money in any way, shape, or form to Mr. Brooks. I think it's the odds of Hollywood knocking down his door to give him lots of money for his life story, I think given the totality of the circumstances of this case, I just think are so minuscule that I don't think that argument should be given much weight. I also couldn't imagine any of the media, whether it's a YouTube blogger or the people that are next door to this courtroom, offering Mr. Brooks any money for some kind of exclusive interview.
I wouldn't give him a damn dime.
I cannot foresee the future with 1,000% certainty, but I think the odds of that, again, are just exceptionally low. I appreciate the fact, Judge, that the state's stipulating that he's indigent. I think counsel mentioned minimum, and I just want to make sure that the court recognizes that we're not talking minimum wage as a legal $17, $18, $19 an hour for prison work. If he's offered work in any of the facilities that he's going to be serving time in, at best he'll be getting perhaps a few dimes an hour for janitorial work or cleaning up the kitchen. The type of wages that are earned by inmates in our correctional system, they're not used to save up lots of money. They're used to sometimes save up to buy a bag of Doritos or some deodorant or toiletries. That's essentially his earning capacity. If they let him work, perhaps $1 or $2 a day if he works the entire day.
Huh, more than he earned on the outside.
So that's the reality of what he's facing. Judge, counsel touched on this, and I appreciate her argument. Frankly, whether you order $50,000 or $500,000 or $5 million, it's very unlikely that Mr. Brooks would be able to pay even the smallest fraction of that. But this hearing still matters. This is not just a moot point or a moot exercise, because you do have the duty, Judge, to balance 5 sometimes competing factors as listed in Wisconsin Statute 973.2013. I mentioned it in my motion, and then, of course, the 5th factor was I sent a letter to the court about that yesterday. The 5 factors are the amount of loss suffered by any victim as a result of the crime considered at sentencing. 2, financial resources of the defendant. 3, the present and future earning ability of the defendant. 4, the needs and earning ability of the defendant's dependents. And 5, any other factor which the court deems appropriate. Judge, I'll go just a little bit out of order. On subsection 4 regarding Mr. Brooks' dependents, recognizing that he's currently serving multiple life sentences consecutive, realistically, he's not going to be able to support his dependents anyways. And so that factor isn't really on point for this hearing. On the first criteria, the amount of loss suffered from the victims, I'm not surprised that the totality could be in the millions of dollars. I'm sure it's an absolutely enormous amount. And you have that discretion to give that factor great weight. I concede that. But I also hope that you consider the next 2 factors as well, and they kind of go together. His earning ability and his current financial resources. I hope that gets great weight as well. She's had significant financial problems even before this case. I believe he qualified for a public defender from day one. If he were to testify, he would testify that he had no savings, no assets. He doesn't have any kind of inheritance coming down his way. Nobody owes him any kind of money. I don't think anybody would dispute those facts. If you add on another $500,000 or $350,000 to what he's already been ordered to pay, which is in excess of $171,000, then you are sending a message that the 2 factors, his poverty, his earnings abilities, just don't matter. And I hope that they should be considered. Finally, Judge, subsection number 5 is the catch-all section, where you can consider any other factors which the court deems appropriate. I'm not sure if the amount of restitution in document 566 is the sum total of what might be requested in future restitution hearings. The law, there is case law that states that a request could be made well past the 90 days after the sentencing hearing. We could object to it, but a lot of courts have upheld those. And I believe, just for the sake of judicial efficiency, since he cannot pay anyways, since he really couldn't raise more than a couple of dollars a month anyways, is it worth the court system's resources, our time, the court's time, the community's time, to have potential extra restitution hearings when the ability for him to pay anything is going to be minimal or nil? And Judge, I guess one last thing. I would respectfully disagree that this is about rehabilitation. Given the length of Mr. Brooks' sentence, I think this is just more additional punishment, adding extra zeros to the judgment of conviction for money that he owes. I recognize the gravity of the harm, and I mean no disrespect to anybody who suffered any injuries or the medical bills from this case. But given the totality of the circumstances, his multiple life sentences, I just don't think it makes sense to add on any additional restitution. It's just more paperwork, potentially extra hearings for no really just purpose except to add extra numbers on the judgment of conviction. I'm happy to answer any questions you might have, Judge, and thank you.
All right, thank you. First of all, I do want to thank the parties again for the stipulation. I think that certainly has made this hearing one that is running quite smoothly, but also kept victims from having to testify again regarding the loss that they suffered, and even, frankly, the representatives from crime victim compensation or the insurance companies related to this. I also appreciate the stipulation from the state regarding the indigency. I think that's a testament to both counsel here and their willingness to, look at this objectively and what the purpose of this hearing and what the court needs to do. It is true that the court does need to consider the statutory criteria in 973.20. That's been referenced by Attorney Covey, both orally here in court today and in his motion to deny restitution. There are 5 criteria, really, when you look at the statute: the amount of loss suffered by any victim as a result of a crime considered at sentencing, the financial resources of the defendant, the present and future earning ability of the defendant, the needs and earning ability of the defendant's dependents, and any other factors the court deems appropriate, really what we would call the catch-all. Obviously, this concerns a case where Mr. Brooks was convicted of dozens and dozens of crimes based upon conduct stemming from him driving an SUV through the Waukesha Christmas parade. There were 73 named victims, one of whom was the victim of the domestic abuse-related convictions, and then, of course, the 6 individuals who perished as a result of his conduct and the 68 others who were injured. There are family members that are represented by each of those victims as well. This was and remains a very significant crime that has and will have lifelong effects for not just Mr. Brooks, not just these victims, but the community as a whole. And the losses that were suffered apart from the death and the injuries is only in part represented by the dollar figures that have been requested by the state on behalf of the victims. And that's what prompted one of the questions to Attorney Opper is that there was, and I think perhaps, I don't know if it still has any money left in it, but we know that there was a fund set up by community members, really funded, I'm sure, if you were to look carefully, probably internationally, with millions of dollars that helped defray costs and the loss to many of the victims. There was testimony, whether during the trial or probably more at the sentencing, of individuals who did not have insurance and suffered out-of-pocket losses, and thankfully the community stepped up, crime victim compensation stepped up, but it would have been significantly more in terms of the dollar amounts that the state is seeking, but for that fund that had been created and used to help the victims of Mr. Brooks's crimes. And so I think that's an important consideration for this court to consider. In addition to the type of loss that was suffered here, I mentioned this earlier, there was death, great bodily harm, certainly emotional and physical trauma, and because this involved a parade and Mr. Brooks driving through it, there's also that sense of security and safety in our community that he robbed not just the parade goers on that fateful day, but really the community, the state. I think anyone who's heard anything about this case would feel a real sense of security that was stolen by Mr. Brooks. I do think the state's argument on rehabilitation is a solid argument. The bottom line is Mr. Brooks completely minimized his conduct both during the trial and at sentencing. And it is important, if only symbolic, that while he is in prison for the rest of his life, that whatever meager sums he might make with a prison wage, that there be a reminder to him why there is this deduction from his monies, that his ability to go to the canteen or to buy some extra item that's not otherwise provided by the prison, that there be that reminder to him that he doesn't have even the full access to whatever money is on his account. Now, I'd remind everyone the law caps what that deduction will be at 25%. I think that's a very clear recognition by our legislature of the balance that the system needs to have as it relates to prison monies. And I think that's an appropriate cap. I also think it's important that this court consider that the vast majority, I shouldn't say vast majority, but a significant amount of the restitution is to crime victim compensation, which is a state fund, largely, if not all, funded by taxpayers. And even if there were some grants that are there from federal resources, which I imagine there might be, that's still taxpayer funded. And so I think that's another consideration for this court to look at and consider. Now, I do have to balance. I'll look at all the criteria. Obviously, significant amount of loss. That's criteria reflected in sub 13 sub A. Sub 13 sub B, the financial resources of the defendant. Clearly, they are extremely limited at this time. However, there is absolutely no doubt in my mind that the possibility exists for Mr. Brooks at some point in the future to possibly profit from a book deal, a made-for-TV movie, a movie, whatever it may be. Maybe it's just doing an interview or whatever the case may be. I don't think that can be ruled out, even if he is obviously the person who was convicted of that, but there was international attention. This court had Court TV in to stream the trial. This court has always streamed every hearing as it relates to this case, in part because of the number of victims, and I could not, I don't have a courtroom big enough in this county to hold all parties involved. Certainly during the trial, this courtroom was packed on a daily basis. And to say that the trial went viral, I think, would be an understatement. And so all of that relates to, though, that catch-all factor and the possibility that Mr. Brooks could come into a sum of money at a later point in time because of the story that he could provide or tell on his own behalf. You need only look at Netflix to know that crime stories are incredibly, they're things people want to watch. People find them interesting. People want to know the why. They want to know the how. And it's certainly not just this case, but we've seen it, and not that that's been on Netflix or anything, but other cases have captured the attention. So I don't think it's beyond the, it's not an impossibility, let's say. It's, I think, a very real possibility that someone might produce something someday for more of a commercial or theatrical type purpose, even if it's a true crime type situation. And that it's possible that Mr. Brooks could profit from that. And that certainly is why, at the time of sentencing, the court addressed the request by the state related to the escrow account. I think that's important to do that here. And so when I balance all of these things, when I consider the significant amount of the loss, the court's desire to hold Mr. Brooks accountable, and even if it's a small reminder with his prison monies, that does serve a very important rehabilitative role, because even though he's serving successive life sentences, we all hope that one day he truly is able to accept full responsibility for what he has done, not minimize his conduct, and so that this award of restitution in full, as the state has requested, is important. And I will grant the additional amounts, as I indicated earlier. It's $10,246.20 to crime victim compensation. That total then to them for the judgment of conviction is $134,466.85. Then to Wilbur and Associates, which is Hartford Insurance, $108,000, $164.61. Optum Subrogation, $118,805.62. And then Progressive Insurance for victim GGG, $10,000, and Progressive Insurance for victim Q, $104,662.64. That is, of course, on top of what a court had already ordered to EMC Insurance of $47,193.29. So again, I'll grant the request of the state. We'll also include that it be payable out of any prison monies per state statute, and the court under 949.165 makes the additional amounts of restitution ordered today subject to the escrow account under that statute. Anything the state thinks I've overlooked as it relates to this?
No, Your Honor, thank you.
Anything the defense thinks I've overlooked as it relates to this?
Judge, I think I'm good. I'll just let Mr. Brooks know that I'll set up a phone call with him soon. If you could just wave your hand so I know that you heard that, sir.
Oh, and
Yeah,
I
you did.
forgot to state this at the beginning of the hearing. Obviously, it had made reference to the video conferencing. He's appearing through the Zoom platform through our technology. It's working. I can see him. You can see him. He's indicated twice now that he hears us. Clearly, the technology is working, and it meets the minimum standards for video conferencing. And given that there was no testimony that was taken today, too, it was obviously very appropriate for him to appear that way. He has 20 days from today's date to appeal the decision of the court. I will, of course, make sure an amended judgment of conviction is done as quickly as possible, get that signed, and that will be uploaded to the e-filing system. All right, thank you, everyone. That does conclude our hearing today. Good luck.
Thank you, Judge.
Thank you, Judge.
Let's sum this up. Judge Jennifer Darrell decided Brooks will pay $523,293.01 in total to victims and insurance companies. That includes the roughly $171,000 in restitution and other court costs assigned in the Brooks sentence. Due to the state's cap, for every dollar he does make in prison, he keeps 75 cents. However, Darrell explicitly ordered that 100% of any future funds he receives from book deals, movies, or media rights must be placed into a designated escrow account to pay his restitution. Now let's clear up any confusion with his appeal. I've done several update videos on it, but still get questions about it in the comments. So for the final time, let's go over it. Darrell Brooks was originally scheduled to file his notice of appeal or post-conviction motion by June 3, 2025. That motion was received in an appropriate time frame.
All right, court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please? Teresa, can you get the, starting with the state, get the notification off? Go ahead.
Good afternoon, Judge. Sue Opper appearing for the state. Thank you for allowing me to appear by Zoom. I'm sorry I'm not present in person.
All right, and you're welcome for allowing me to appear by Zoom, and I certainly understand this was set quickly. Your appearance, sir, please.
I'm here as a third-party intervener in this matter under special appearance. Not sure what this court date is about, but as you can see, I'm not allowed to have any legal paperwork at this time. I was placed on the protocol. I watched protocol without even being suicidal. I still would like the rendering of the accounts in this matter, if I may.
Mr. Brooks, the court set this because you had filed one document on the 15th that I construed as a motion for a stay pending appeal. And you may or may not recall, but when the state asked me to consider that at the conclusion of Wednesday's hearing, I indicated I would wait until all of the judgment of convictions had been signed and then schedule a hearing. I have signed the judgments of conviction, and because of some of the procedural, if you want to call it that, things that have happened. I know you were taken to Milwaukee for what was supposed to be a jury status hearing on 2 matters. I thought perhaps they would keep you there, but it's my understanding all of those dates were adjourned, and so you were brought back to the Waukesha County Jail. And so since you are going to be here, I thought I would schedule this for that motion hearing in order to address that. I can see very plainly you don't have any of the documentation. In an effort to be fully transparent with you, that one piece of paper apparently did not get scanned into the electronic file, and we're having some trouble finding the paper copy at the moment. And so I don't even have it in front of me. Clearly, you don't have it in front of me. I believe we gave you a copy of you gave us 3 inmate communication forms together. Do you remember that on the 15th?
I don't recall giving any ICFs. I recall submitting the notice of right to appeal.
So I recall it being 3 inmate communication forms, but I thought they were brought into court. I could be mistaken on that. That was my recollection. One, at least it was received by us on the 15th. One requested a certified copy of the record and waiving fees. Another, and that one was dated the 13th. Another that said the 4th, but I believe it was from the 14th, talking about waiving costs and fees.
Oh, I recall. I didn't mean to interrupt. I recall that was the week before last when I submitted that one that you just referred to.
Okay, and then there was the 3rd piece of paper, and I know the state had asked for a copy of it. When I had referenced, there were some filings My clerk is telling me she recalls the last one being on a plain sheet of paper that you brought with you into court. It was copied for all the parties, and unfortunately, we're having a hard time finding it at the moment. It's not scanned into the file. They do a large auditing process. It hasn't been picked up yet. We feel it's around. We just need to file it or find it. So if need be, I can simply reschedule this for a time when you have it in front of you, when the state has it, and when I have it in front. But that was my hope, to address it today. If you wanted to address it orally, I could do that as well.
No, I would rather, all the paperwork was all in my legal work, which obviously right now I'm not allowed to have. So
That would still be in your cell?
no, they took everything out of my cell. I'm not allowed to have anything in my cell, no paperwork, no mail, no hygiene, anything.
Do you believe if given access to it, you would be able to identify and find the one piece of paper that I'm talking about?
Was that the actual motion?
I believe it was a motion for stay pending appeal.
See what happens when Sue Opera goes on vacation. The court is actually relying on Brooks to find a piece of paperwork. Wait, did they check the garbage can in the other courtroom?
Yeah, I'm sure. I don't see the thing, just so the court is aware, Your Honor. When they strip your cell, because I had so much legal work, they kind of just put them in like boxes, and I'm not sure where they take them. I don't know if they take them to property, or I don't know if they keep them close. That part I don't know, but they kind of just put everything together. So I would need some time to actually shift through to see what's in the place, if that helps.
I totally understand. I'll be in communication with the jail officials and let them know I need you to have access to the legal documents that were taken from your cell so that you can locate this form and have it refiled with the court in the event we're not able to find it. I apologize for that. If you were to see everything that I normally have up here, and certainly at the conclusion of a month-long trial, I have a lot of paperwork.
Yes.
I'm still looking through my notes. I haven't found it yet. Again, I think it's just because we're under the gun to find it. We're not finding it. And what I'll do is I will just simply reschedule this. What it may mean, though, is it will be after you are transferred to Dodge, and then I'll have you appear by video for that.
I do. I actually, as soon as, obviously all this took place, as soon as I walked out of court, I went right into this. I had been asking them for the last 2 days about the legal work, because I knew this was going to come up at some point. I'm like, can I at least just have access to my legal paperwork? I'm not asking for anything else, just that part of it. And it's kind of just like the whole runaround thing. Like, I don't know if
I will be in communication with them. I obviously don't know all of their procedures and protocols, and I want to be mindful. If they've put you on a suicide watch, they do that for a reason, but if need be, I will require them to give you access so we can find this piece of paper and have it refiled with the court. And then once that happens, I'll schedule it for a hearing, but it won't be next week. It might not be till the week after, just because of some time that I have off and needing to make sure everyone has copies of it.
Just so the record's clear too, Your Honor. They said this was procedural protocol. It wasn't because I demonstrated any suicidal behaviors or even said it. I was told it was just protocol. So it wasn't because I said anything or exhibited any behaviors that would make them think I was suicidal in any way. I was told it was just...
I think he's repeating that because he wants the world to know. But he's been in a cell by himself, so he probably loves the opportunity to get out and run his mouth.
Protocol.
Understood. All right, so I'm not going to hold up any transport because of this motion. It's a motion that can be addressed with you appearing by video. It's a procedural motion. Obviously, if I were to grant any of the relief that you seek, that might change where you're being housed, but that's a little speculative at this point in time. But just so you know, it might not be scheduled for a couple of weeks. We need to locate it.
Is there any additional paperwork that I may need to file in regards to that, or?
Well, I can't give you legal advice, sir.
I'm not asking that. I'm just saying, is it?
Hold on.
Obviously,
At
I'm
the
not.
end of the hearing the other day, the court provided you with the written explanation of life sentence, written explanation of determinate sentence, and then the notice of right to seek post-conviction relief. And actually, you acknowledged that. You indicated you planned to seek post-conviction relief. You dated it. And that is on file. I'm sure what we will do is forward that to the public defender's office. That's typical when there's been a conviction and someone's in custody, to see if you qualify, which presumably you would, for public defender representation. What you do with that is up to you, but that's typically the process. And I'm sure they'll be in touch with you about that.
Will I be able to have access to the paperwork that you just referred to, that not the appeal part, but the other paperwork that you referred to?
The motion that you filed?
No, the something you said you provided.
A written explanation of?
Yeah, all that paperwork. Would I be able to have access to that? Because obviously, when it was given, was right after everything had wrapped up Wednesday, and as soon as I walked out, they took all that. So.
I'll indicate to the jail administrator that it's 20 pages in total. It's at least labeled in our file as written explanation of determinate sentence, but there's 20 pages because of the number of counts involved. That and the motion for stay pending appeal, however it's phrased, will be provided to you. And if you even want the copy of the notice of right to seek post-conviction relief, you should have received a copy back, but I'll indicate that should be provided to you as well. Okay?
And actually, Judge, I think if we're going to reschedule this at a time when he's in the prison, we may encounter the same problem, that he may not get immediate access to his paperwork, so we may want to take that into account when we schedule.
Okay.
Yeah, Attorney Opera is right about that. From my understanding, I was told you have to go through an intake process when you're don't have access to certain things. I guess I won't know for sure until I'm actually there. But to my understanding, that is the process.
Why don't I do this? Once we get the paperwork that we need that's in your property inventory, presuming that's where it is, and I'm able to set the motion, I'll make sure that when we send a notice of hearing, that all of these documents I've just talked about are copied and sent with it. It would be my hope and expectation that might get to you because it's being sent from the court. And then we'll go from there.
And if I'm not in possession of anything, should I just let you know that if it's anything that I may be missing at the time of the hearing? Would it be okay to let you know what I have and don't have? And
I think that would be fair. Yes.
Thank you, Your Honor.
As you consider the issue, which is a motion for stay pending appeal, I would direct your attention to Wisconsin State Statute 808.07. And there's case law that supports that, but it's the factors the court must consider for a motion for stay pending appeal. 808.07.
808.07?
Yes.
Would I be able to look that up, considering that I
I'll
don't
make
have
sure.
anything right now?
I'll include that in the cover letter.
Should we send him the pro se manual on appeals?
Do you want the pro se manual on appeals?
Yes.
We'll send you that too.
Thank you.
You're welcome. All right. Attorney Opper, then anything else? Are you satisfied with the procedure I've outlined here today?
I am, Judge. I just wanted the record to reflect we did comply with victim rights notification. I do have a copy of the motion. I agree with the court's recollection. It was written on a plain piece of paper and it was formatted like a motion typically would, with the caption and the heading of the motion. As you know, I'm not in the office today, but when I return on Monday, I'm certain I can put my hands on my copy and provide that to the court and Mr. Brooks if that is necessary.
All right, thank you. I would appreciate that. All right, anything else from you, sir?
No,
All right, my apologies for
Yeah,
misplacing the
I was kind
form.
of shocked. I was just like,
But-
what's going on?
That's okay. I wanted to try to address an issue that you raised, but as you can
I would
see,
have hoped to have been prepared, because when they said you have court, I'm like, I have nothing. Like, I'm just going in
All
here
right.
with nothing.
now you know what it's about. We'll make sure we get some documentation to you. And once we locate that, we'll have it scheduled, and I'll have my clerks contact the receiving institution to find out the best timing for all of that, and to make sure that whatever paperwork the court sends to you, you actually receive. All right. All right, no new dates then at this time, but that motion will be scheduled as soon as possible. All right, thank you, sir. That concludes the hearing.
Thank you, Attorney Opper.
Okay, thank you, Judge.
You're welcome. All right, I'm going to stop the live stream then.
Hang on. Did he say what I think he said?
Thank you, Attorney Opper.
Oh, shoot. I think she was talking and missed it.
Thank you, Attorney Opper.
Okay, thank you, Judge.
You're welcome.
I need to hear that one last time.
Thank you, Attorney Opper.
He drew national attention when he defended himself during the Waukesha Christmas Parade trial.
And Darrell Brooks is again making an effort to represent himself, this time for his appeal.
You heard that right. For those of you unfamiliar with the trial, he once again wants to take the reins away from his attorney.
Leslie Beasy and Zach Wichow.
Good afternoon. Attorney Michael Covey appears. Mr. Brooks appears in custody via Zoom.
Mr. Brooks, can you see and hear the court? He's giving me a thumbs up. Are you able to also see your attorney through the Zoom?
What was that?
Are you also able to see your attorney on Zoom? All right, and that's a yes, sir?
Yeah.
Can you answer verbally, please?
Yeah.
Thank you so much. And any objection to appearing remotely today, sir?
No.
And has the state complied with victim rights?
Yes.
As everyone is aware, the court is live streaming through the daycast function of Zoom that CCAP has made available for circuit courts in Wisconsin. And we've been able to verify it is up and running. If at any point in time anyone gets word that it is not, please let me know. We are here today to address a motion to withdraw that was filed by Attorney Covey. I do want to ask you a number of questions. The first question is it your understanding that Mr. Brooks would still like you to pursue this motion?
Yes, Judge.
All right. And Mr. Brooks, could you also confirm that for me, that you are seeking Attorney Covey to be relieved as your attorney of record for your appeal?
Yes.
For purposes of today's hearing, District Attorney Basie, do you agree, or is there any dispute that Mr. Brooks is indigent?
I have no information to say otherwise.
All right. And do you have any dispute that we are concerned with Mr. Brooks's direct appeal rights at this point?
No concerns.
All right. Do you agree with those two issues, Attorney Covey?
Yes, Judge.
All right.
He's absolutely indigent.
He's in custody. He's serving consecutive life sentences. He's indigent, and initially, even when he was the accused, was eligible for public defender representation. And do you have any information, Attorney Covey, that would suggest otherwise?
No, Judge.
All right, thank you. Then let me start with some questions. What I intend to do is I want to make a record of a number of things related to the inquiry that this court must make under the law. I think it's important to start with directing the questions to counsel, because as of right now, you do represent Mr. Brooks, and then I intend to address some questions to Mr. Brooks as well. Attorney Covey, have you received and have you reviewed the February 26, 2025 letter from the State Public Defender's Office?
Yes, I have.
Are you aware or have any knowledge of whether that letter was received by Mr. Brooks?
It's my belief that it was sent to Mr. Brooks and that he has received it. I haven't confirmed that with him personally, though.
All right, I intend to do that in short order. Is it true, Attorney Covey, that you were appointed for the purposes of investigating and pursuing potentially an appeal for Mr. Brooks on January 6th of 2023?
Yes, Judge, I was appointed for post-conviction and/or appellate relief.
Thank you. And what have you reviewed in your work on this case thus far?
Judge, I have spent probably hundreds of hours. I know this past summer, the vast majority of the summer, my free time was spent reviewing this case, including all of the transcripts, the entire court record, the vast majority of the discovery. I'll make a record of that. There's certainly, when we get provided with lots of audio, video evidence, not all of it is directly relevant to the offense. If, for example, if there's a squad video that's just pointing against the wall, I'm not going to spend hours reviewing that. But the key evidence, the interviews, the court exhibits, I definitely reviewed all of that discovery as well. That we have about 5 banker's boxes of materials that I have gone through, including the prior attorney's notes before Mr. Brooks went pro se.
I like Attorney Covey. He's very thorough. Listen closely to this next portion. Most importantly, everything Covey says, and tell me if you think he found anything to appeal in his research.
Have you met with Mr. Brooks either in person, by phone, or in any other way?
Judge, I have, and of course I can't talk about the substance of that, but I have met with them in person several times, plus numerous phone conferences as well. I haven't counted, but a large number of contacts.
Have you had written communication with him as well?
Judge, I'll write him letters. Mr. Brooks and I would generally communicate via the telephone, mostly telephone and in person.
Have you sought a number of extensions from the Court of Appeals related to the timing of filing any post-conviction motion or direct appeal?
Judge, I have basically 2 groups of extensions, if I may explain. The file is huge. And so it definitely took me longer than normal to review the contents of this case. And so the first few extensions were just to get me through the summertime where I was able to review all those banker's boxes of materials. The second set of extensions were filed so that Mr. Brooks, after him and I had fully consulted each other, would have time to decide how to proceed. I know one of my more recent extensions was to give Mr. Brooks the opportunity to try to hire a different attorney if his family was able to do so. That's part of the public record, of course. So those are the 2 groups of extensions that I filed over the course of the last year and a half.
Do you know how many?
The most recent extension was the 7th motion to extend time. That was to give, I'm sorry, my apologies.
The record shows that on
I think there was
February 14th, the 8th motion to extend was filed with the Court of Appeals. Would that seem accurate?
Yeah, I misspoke. It's the 8th motion to give Mr. Brooks time to litigate his case. In the event that I withdraw, he'd have a couple of extra months to review the file and to do his own research.
Again, I understand that you can't discuss confidential communications with Mr. Brooks as his attorney, but generally speaking, have you identified issues to pursue on appeal?
Judge, I can say this. There were several very specific issues that I spent an enormous amount of time researching for appeal as to whether or not there were viable post-conviction or appellate issues. I'm not able to say without breaking privilege.
It could be two things. One, he wasn't able to find anything and told him to seek a second opinion on his own dime. Or did he tell Brooks that there are some areas to pursue that were beyond his appellate knowledge?
Have you sent Mr. Brooks any drafts of pleadings related to any appellate or post-conviction issues?
Judge, since I haven't filed an actual appellate brief, we haven't done the notice of intent to appeal, nor an actual post-conviction motion, there wouldn't be any pleadings for me to send him. So we're at the point, if I may, give a little bit more elaboration. Usually it's a two-step process for post-conviction relief. The first part's actually the longest. It's assembling the court materials. I know the court reporter worked exceptionally hard to get me those materials, but that took a few months. Going through those materials, identifying issues that could provide post-conviction relief. In some instances, there are no grounds for post-conviction relief, and then there's a different set of options that I would go through with the client.
What does that mean?
So after going through all of those steps, I did have multiple contacts with Mr. Brooks, both in person and over the telephone, for him to decide how he wants to proceed. I'm not able, even if hypothetically I found 5 amazing viable grounds for post-conviction relief or appeal, I wouldn't be able to submit any post-conviction motion or notice of appeal without the consent of Mr. Brooks. If I found no grounds for post-conviction relief, then again, Mr. Brooks would have a set of options that I would have to go over with him. And I can say that we have gone through that process.
Well, if they've gone through that process, then there is nothing he found.
And he has requested to proceed pro se, which would prohibit me from filing any further pleadings in this matter. I hope that clarifies the issue.
Well, it helps because my responsibilities ultimately when discussing with Mr. Brooks is to talk about the options. One option could be a no merit situation. So I generally just want to know if all options have been discussed with him at this point.
Absolutely, Judge. That I can say 100% certainty. And multiple times.
Is it your understanding that Mr. Brooks wants to proceed pro se or on his own, or as he sometimes referred to it as in pro person, I think was the phrase he used with some frequency?
Judge, he does want to represent himself moving forward.
Have you discussed with Mr. Brooks your background as an attorney and doing appellate work?
Judge, I don't, it's a innocuous question. There's no issue with me answering it, but I'm afraid that if I were to go into any discussions.
Let me ask it this way.
Yeah.
So I would like Mr. Brooks, and I'd like, actually, let me state it this way. I would like the record to reflect your experience for purposes of my decision here today. So I'll just ask you some general questions. They would not in any way violate any type of attorney-client privilege. First of all, how are you a licensed attorney in the state of Wisconsin?
I hope so. I also am in a lot of trouble today. Yes, ma'am.
How long have you been so licensed?
Approximately 20 years, actually 22 years, I believe.
Do you hold licenses in any other states or have permission to appear in any other courts outside the circuit courts, appellate courts, and Supreme Court in the state of Wisconsin?
Judge, I did take and pass the Illinois State Bar, and I was part of that community for a few years. I let that lapse because I solely practiced in Wisconsin.
What about federal courts?
Judge, I was trained to do some federal courts, and I was actually accepted to be an attorney in the Western District. Then COVID struck, and the caseload for the states became so extreme for lack of public defender appointments that I never ended up practicing in federal courts.
Do you have any area that you focus on in your practice?
Judge, I focus mostly on homicides and sexual assaults, if I may. The State Public Defender's Office, let me backtrack. I'm not a public defender. I'm a full-time criminal defense attorney. For most of the last 20 years, I had my own practice. Recently, I joined Kerryctures for his law firm, CHIRAFISI. For most of the last 10 years or so, I have been practicing mostly homicides, class A, B, and C felonies.
Give me 1 second. Mr.
Sure.
Brooks, would you please direct the camera up? Thank you so much. I appreciate that.
Judge, the State Public Defender's Office has certifications to take certain levels of felonies. The highest level of certification is Class A felony, and I'm certified to do those in both the appellate and the trial court level. Approximately 20% of my work is with appellate work. I'm in trial more often as with the circuit courts.
In your litigation practice, both in the circuit courts and appellate courts, that's both through appointments and individuals who would privately retain you?
Absolutely. I have the highest level of certifications the Public Defender's Office can give.
Thank you. Have you had any general discussions with Mr. Brooks related to appellate rules and procedures, whether it be formatting, initial briefs, what response briefs are, the requirement for reply briefs, or even the difference between that and a post-conviction motion?
Judge, let me just say this again. I've certainly had lots of conversation with I've spent hours with Mr. Brooks in person and over the telephone. I'm going to speak in very, very general terms. The vast majority of those conversations have to do with the substance of the case itself, the issues that I was researching on this case, and there were some very specific issues which I'm declining to say now for privilege reasons, but that I was researching on this case, going over the case law, meeting with them to discuss lots of different issues. Certainly as part of that, I would have, with every one of my appellate clients, I would have conversations about basic appellate procedures, such as the difference between a post-conviction motion and going straight to the Court of Appeals and why that would occur. That is, as to the details of drafting a brief, rules of citation, the fonts and procedures that you have to do to submit an appellate brief. I, of course, have not had those types of conversations because it was my intent that if there was an appellate issue, I would be drafting that brief. I can say this, and I'm happy to do this to allay the court's concerns. Certainly, it's my intention to send Mr. Brooks a copy of the rules of appellate procedure for Wisconsin. We'll make sure he gets that. Additionally, in my experience of doing this for a long time, though the Court of Appeals will still hold pro se defendants to the letter of the law and the substance of the case, they won't give the pro se defendants any breaks on the substance. If there is an issue with page numbers or citations for a handwritten brief that would be submitted by a prison facility, I've never seen an issue where the Court of Appeals has objected to that. They're a little bit more lenient on those issues for obvious reasons.
Thank you. That was I don't want to say a concern, but a question I had, and that's good to hear. So thank you. Is there anything else you want me to consider in light of the motion that you filed with the court?
Just that I'm not, even if I was allowed to withdraw it today, I'm not going to close the file until Mr. Brooks has the entire file. I was speaking with our paralegal staff just yesterday, going through multiple bankers' boxes of materials. The facility where he's being kept at right now will not accept those materials. It's just too much for them to take in. However, if we scan them, download them, and put things on hard drives, multi-gigabyte hard drives, we can send those out. So it will be a very lengthy, time-consuming process for us to do so, but I'll make sure Mr. Brooks gets those materials with one caveat. Because of the time and expense to do that, we wouldn't be making multiple copies. So if something were to occur where Mr. Brooks would want another full set of materials, perhaps 8 months from now, it would be challenging for my firm to comply with that request.
So let me make sure I understand this. The prison facility at which Mr. Brooks is currently serving his sentences will not accept the volume of material that you have in paper or even standalone electronic other than on an external hard drive.
If we set them disk and flash drives, I'm very confident the prison would accept that. But they made it clear to our office, and it was their staff speaking with my staff, that they would not accept, if I were to ship 5 bankers boxes of materials, they would not accept that. But if we put those materials on computer electronics, then they would have a place where they could store it safely and easily, where Mr. Brooks could access it in their library.
It is not a secret that Mr. Brooks is no longer being held in Wisconsin. If he were in Wisconsin, would you have had better access to him in terms of going to the facility, even with your own computer and as his attorney showing him discovery if need be? So
I was able to visit Mr. Brooks at the Dodge Correctional Institution and additionally at the Wisconsin Secure Program facility in Boscoville. The prison facilities made it very easy for me to do the visits. I was able to bring my case files. I wouldn't have brought that volume of materials to a meeting anyways, had I desired to go through any piece of audio video evidence. There would have been a mechanism for me to do so in Wisconsin. If hypothetically, if I were to remain his attorney, I am able to have telephone and Zoom conversations with my clients. It would be a little bit more onerous for me to do in-person visits.
If you were able to do Zoom, you obviously can share screen, even information from your computer.
If that's what we wanted to do.
Do you know what, if any, materials Mr. Brooks was able to take with him from his trial to the facility where he is at?
Mr. Brooks might be able to answer this better than I will, but it's my understanding that somehow along the way, when he was transferred out of state, he no longer has those trial materials. So we would be working to give him a complete set of what we have. And that would also include downloading all the materials from the e-file and putting that on a separate flash drive as well.
But you're willing to do all of that?
Yes, we will get extra funding from the Public Defender's Office to get extra paralegal support to do that.
And they're willing to do that as part of the case closure should this motion be granted?
I have not put in that request yet, but I am certain they'd be willing to do it. They've done it before on other cases that were also very serious cases. I'm sure I can get the funding.
All right, thank you.
And frankly, if we didn't get the funding, we would do it anyways.
Well, I appreciate that. Thank you. All right, Mr. Brooks, I'd like to ask you some questions. First of all, are you aware that Attorney Covey has filed a motion to withdraw as your appellate counsel?
Yes.
And just as a reminder, even though I tried my best to talk to you at my cameras, when I want to watch you for your response, I look slightly down and to the right, or even to one of the other monitors that I can look at. So I just want you to be aware that when I do that, I'm actually paying attention to you. Any questions about that, sir?
Yes, he is covering his nose and mouth in a really weird way. We think maybe he got the crap beat out of him. I had to retrack some information I previously released by deleting a video about him getting attacked in jail and where he was relocated to. It turned out to be incorrect information. Someone else mentioned he had dental work done and they had to remove some front teeth. His mouth does look swollen either way.
Do you want to have attorney Covey withdraw and act as your own attorney, sir?
At this time, yes.
The public defender's office sent to this court a letter dated February 26th of 2025. It is front and back. I think the actual filing had some additional information on the third page, but that had more to do with who was copied on the letter versus the crux of the letter. But did you receive a copy of that, sir?
From what was the date?
February 26th of 2025.
I don't believe I received that.
Mr. Brooks, would it be helpful if at this point I switch to a single camera when I'm talking directly with you instead of having the multi-camera view?
I can see you just fine.
Okay, great. So I'm just going to read the letter into the record, sir. It's important. It is from Kelsey Loshaw, the regional attorney manager from the Madison Appellate office. Does that ring a bell at all?
I think from previous letters, it might, yeah.
Well, this one is specific because it was filed after the motion to withdraw was filed, and there's a requirement in Wisconsin statute 809.30 that the public defender's office advised the court of certain information. Does that help ring a bell, sir?
No.
All right, then bear with me. I will read the letter. It says, "Dear Clerk, in accordance with Wisconsin statute rule section 809.30 sub 4 sub B, I'm writing in response to the motion to withdraw filed by the SPD appointed appellate attorney Michael Covey. The rule requires the SPD to determine whether successor counsel will be appointed and notify the court of the determination. I ask that you pass this on to the judge assigned to the case because the judge is required by Rule 809.30 sub 4 sub C to consider the SPD's response prior to ruling on the motion. The state public defender informs the court and Mr. Brooks if the motion to withdraw Mr. Brooks directed attorney Covey to file is granted, Mr. Brooks will be waiving his right to public defender representation, and no new or successor public defender attorney will be appointed." Sir, have you heard what I just read to you?
Yes.
Are you aware of the risk you take as it relates to to a public defender appointed appellate attorney if this court grants the motion to withdraw?
Yes.
Do you have any questions for me about that?
No.
The letter goes on. An indigent person's right to an appointed attorney for appeal does not encompass a right to an attorney of choice or to successive appointments. State v. Evans, 2004, Wisconsin 84, 273, Wisconsin 2nd 192, paragraph 30. If a defendant decides he no longer wants to be represented by an appointed attorney, he has the choice of terminating counsel's representation and proceeding pro se or with retained counsel. Id at paragraph 31. If a defendant elects to discharge his appointed attorney and proceed pro se, the defendant must be provided clear warnings regarding the dangers of self-representation before appellate counsel may withdraw. Id. Sir, did you hear me read the second paragraph of this letter?
Yes.
Do you understand it?
Yeah.
you have any questions for me regarding that?
No.
The letter goes on to provide the legal framework for the court's responsibility in determining whether a defendant validly waives counsel on appeal. And I'm going to read that paragraph. It is a direct quote from a case, State v. Thornton, 2002, Wisconsin Appellate 294, also found at 259, Wisconsin 2nd 157. For your information, State versus Thornton is a Court of Appeals case that dealt with an issue for the first time in Wisconsin in a decision dealing with the court's responsibilities in determining the waiver by a defendant of counsel on appeal. And in that particular case, and this paragraph starts out by giving a little statement about the state's summary of the issues. The state offers the following synthesis of the foregoing decisions. Before a court may conclude that a criminal defendant has knowingly and voluntarily waived his or her right to counsel on direct appeal, it must satisfy itself that the defendant is aware, 1, of the Flores rights, parenthesis, to an appeal, to the assistance of counsel for the appeal, and to opt for a no merit report, parenthesis, 2, of the dangers and disadvantages of proceeding pro se, and 3, of the possibility that if appointed counsel is permitted to withdraw, successor counsel may not be appointed to represent the defendant in the appeal. The court went on, we agree with the state that ensuring a defendant has received and understands the listed information is both necessary and sufficient to support a determination that the defendant tendered waiver of counsel is knowing and voluntary. In that particular case, the issue or the procedural posture was that the appeal was already pending. And so the Court of Appeals had some further things to say about the communication with the defendant being written. That's not applicable here. I'm having a over Zoom face-to-face discussion with you, but this is the framework that will guide the questions that I ask. Do you understand that, sir?
Yeah, I'm familiar with that case law as well.
Thank you. Any questions for me thus far?
Nope.
All right. So I just want to confirm, sir, did you ask Attorney Covey to withdraw?
Yes.
Did he send you a copy of the motion to withdraw?
Yes.
Have you reviewed it?
Yes.
Do you have any questions about it?
No.
Do you take any issue or claim made by Attorney Covey in dispute?
No.
Did you at any point in time tell Attorney Covey you're fired?
No.
All right.
Judge, if I could just clarify something. The conversations I've had with Mr. Brooks in every instance, they were quite respectful. There was no arguments. So when Mr. Brooks when he asked me to withdraw, it was in a polite, respectful way as opposed to a "you're fired, get out."
Great. Thank you. I appreciate that clarification. I still wanted to ask from his perspective. All right. Any dispute with what Attorney Covey just said, Mr. Brooks?
None whatsoever.
All right. Why do you want Attorney Covey to withdraw?
Judge, if I may, Mr. Brooks, this question could call into some privileged information. You have every right to answer the question. You and I have had lengthy conversations about the substance of particular issues that I have looked at and my conclusions on those issues. I don't think it would be to your advantage to go in that direction. You could definitely answer the judge's questions, but I would just be guarded as to going to the substance of any legal research that I may have done, that I did do. Thank you, Judge.
You're welcome. I appreciate that. I can ask it in a more general way. Mr. Brooks, again, understanding the caveat that your attorney has given you, how would you characterize in general terms the reason you want to proceed pro se? Is it a strategy disagreement, or do you simply just want to represent yourself pro se?
The public deserves to know.
I just want to represent myself.
So let me ask you some real specific questions then about some access to research materials and other things. I believe these questions go to your understanding of the difficulties and disadvantages as a pro se appellate litigant. Most of the time, if you file in the Court of Appeals, it is a written process that may or may not include appellate arguments in front of the court. Do you understand that?
Briefly, I understand the outline of what you're saying here.
So you're prepared to follow the rules and procedure of appellate procedure and submit written submissions, whether it be to the trial court or to the appellate court related to your post-conviction and appellate rights?
Yes.
Do you have, or what access do you have to legal research at the institution at which you are currently serving your sentences?
Honestly, not very much. It's very different. So it would take some time, and maybe a few conversations can be had in that area, but
He has no plan.
I mean, I don't know if that answers your question.
You've answered it. Thank you. Do you understand that could lead to further delays in your appeal or post-conviction motion?
He's not prepared at all.
Yeah, I do understand that. I kind of anticipate that with where I'm housed. It's like I said, it's a lot different. Things are done totally different here. So I'm aware that could pose some issues.
You don't dispute that you're no longer in Wisconsin serving your sentences, correct?
I'm sorry, can you repeat that?
You agree, I earlier said you're no longer in Wisconsin serving your sentences. That's true?
I would rather not say.
Judge, I can verify that he is no longer in Wisconsin. The Department of Corrections had requested me personally not to disclose his location. Of course, it's up to the court. I'm sure at some point it's going to get out. But I just had a conversation.
Let me answer that for a second, because
Sure.
we can take a brief segue.
Sure.
I am treating Mr. Brooks no differently than I would treat any individual who's serving a sentence in the state of Wisconsin. I repeatedly asked the Department of Corrections for information where he was at. I am a separate but equal branch of government, and they thwarted my efforts. I was only told he's in South Dakota and given email addresses for individuals that we could have contact. I need to be able, as the court, to send communication to him directly. That would be no different for any other inmate in the state of Wisconsin, whether they have an attorney or not. So today I directed my clerk to send an email to South Dakota and ask them for the information. It was provided and it is on CCAP. I have received no requests to seal an address. I have received no legal authority from anyone and no request. And so I'm treating Mr. Brooks the same that I would treat any individual, and that information is now on CCAP.
Thank you, Judge.
Mr. Brooks, do you believe that despite some of the challenges that you described, or at least stated about access to research, that you'll be able to overcome that if you are representing yourself?
I mean, like I said, it's going to be difficult, but there are conversations that I'm sure can be had to aid me along the way. But I mean, I have to be honest and say that it will be very difficult.
But do you understand that's the risk you willingly take if you want to be your own attorney and proceed pro se?
It's a risk. It's a risk regardless whether I was in Wisconsin or not. It's just going to be, the question was based on where I'm currently housed, which is more difficult than if I was still housed in Wisconsin.
I understand what you're saying. I'm aware, but do you acknowledge, sir, that that is a risk that you willingly take by asking if I approve the motion to withdraw and you appear as your own, you proceed as your own attorney? Do you understand that?
Yes.
All right. And again, I'm not trying to be nitpicky here. I'm trying to make a record, and I believe it goes to the dangers and disadvantages of being a pro se appellate litigant who is serving multiple consecutive life sentences, meaning you're in custody, further complicated by the fact that you're serving those out of state, and you don't apparently have the same access to resources as you would in Wisconsin. Do you disagree with anything that I just said?
No.
I want you to be aware, sir, that you have the right to counsel on direct appeal. Do you understand that?
Yes.
Do you have any questions for me about that?
No.
As you know, Attorney Covey was appointed by the State Public Defender's Office, meaning at the government's expense, to investigate and review your appellate options, and that the Public Defender's Office, through that letter that I read to you, has advised they will not appoint successor counsel under really any circumstances. Do you understand that?
Is he doing something shady? Watch how he checks to see if they are watching him over to his left side.
You want me to restate that?
No, I say yes.
Oh, I'm sorry. I didn't hear you. You covered your mouth, so I couldn't even see your mouth moving. All right. You understand that, sir?
Yes.
Do you have any questions about that for me, sir?
No.
The right to counsel in this circumstance, and I'm referring to not only 809.30, but the Wisconsin Constitution, Article 1, Section 21, includes the right to a direct appeal, the right to assistance of counsel for the appeal, and includes such thing as the right to opt for a no merit report, and abandon an appeal, essentially. Do you understand all of those things?
Yes. Yes.
Thank you. The right to counsel, however, does not include the right to appointed counsel of your choosing. Do you understand that?
Yes.
It also does not include the right to insist that your appellate attorney pursue issues which he, in his professional judgment, choose not to advance. Do you understand that?
Yes.
In other words, if the only dispute, let's say, is over strategy and you change your mind later on, in that circumstance, the SPD will likely not reappoint. I mean, they've said that in their letter. You can change your mind. You can have remorse, regret. You could try to find your own retained attorney. And if that doesn't work out, that once this court grants the motion to withdraw, they will not appoint successor counsel. Do you understand that?
Yes. And to be clear, there was no disputes between me and Attorney Covey. So there was no strategy disputes. There was nothing of the sort.
Sir, I know from presiding over a previous hearing related to the waiver of attorney that we spent a fair amount of time going through your background. And I just want to confirm a few things with you. You can read, write, and understand the English language?
Yes.
You completed high school through the 11th grade and obtained an HSED. Is that also true?
GED.
A GED. All right, thank you. Are you currently taking any medications that would interfere with your ability to understand what is going on?
Not currently, no.
All right. Do you have any medical issues that would interfere with your ability to understand what's going on today?
No.
Are you under the influence of any alcohol or drugs today?
No.
It is also true that throughout the trial in this case, you represented yourself.
Yes, that's true.
Is there anything about this court hearing thus far that you have not understood?
No.
Are you asking this court to allow Attorney Covey to withdraw as your attorney of record?
Yes.
If you change your mind, I want to confirm once again that you are aware the Public Defender's Office will not appoint successor counsel.
Yes.
Are you aware that if you can't hire or retain an attorney on your own, the Public Defender's Office will not appoint successor counsel?
Yes.
Do you understand, sir, that you will be responsible for all aspects of your post-conviction litigation and appeal, including compliance with all court rules and procedures?
Yes.
Anyone make any threats or force you in any way to waive your right to an attorney in this case?
No.
Anyone make any promises to you in exchange for your waiver of right to an attorney?
No.
Do you believe you're making the decision to waive your right to an attorney freely, voluntarily, and intelligently?
Yes.
Do you need any more time to talk to Attorney Covey regarding your request that he withdraw?
No.
Do you further understand you may need to file motions in the Court of Appeals seeking an extension of time? Given the most recent extension goes to June 3 of 2025.
Yes, I'm aware. I didn't know it was that soon, but yes, I do understand that.
Judge, may I jump in for 1 second?
You may.
Thank you. And just for the record, we have sent Mr. Brooks copies of all of our extension motions and the Court of Appeals decisions. What I will do for Mr. Brooks is I'll send him again that my most recent extension motion that he can use as a template, and I'll include a closing letter with the instructions as to how to file that and to use a pre-appeal case number, some of the basic procedural issues that might help him understand the difference between a post-conviction motion and going straight to the Court of Appeals. Is, from my experience, the Court of Appeals is pretty lenient in giving at least several extension motions to pro se defendants. At some point, they'll put some harsher deadlines on. It's a gray area, but I am very, very confident that he'll have more time than June 3rd if he makes a proper request to have more time. It might take a couple of weeks for us just to get at those files to him. We've been working on it.
Mr. Brooks, do you understand that if the court permits Attorney Covey to withdraw today, you would be responsible to file the next extension request?
Yes.
And you are prepared to do that?
Well, once I receive the templates that Attorney Covey is going to send me, yes, I'll be ready to do that.
You understand he's not required to do that. He's just offering to do that, and it would not.
I know.
All right. You understand that's still something you are responsible for, whether he sends you that template or not.
Yes.
Is there anything else you want me to know or consider today, Mr. Brooks, as I consider the motion to withdraw?
Not really. I think everything was pretty much covered. Just understanding should be there that, again, this facility is a lot different. So there are different types of hurdles that I've already seen that I would have to jump over to be able to get things done. So I just want that to be stated for the record, that it's just a lot different. And there's a lot of different procedure wise things here. So I'm still navigating that, as I haven't been here that long. So I'm still learning as I go. So that's it.
And you're willing to take on your own case with that difficulty and those challenges related to the institution?
At this time, yes.
Attorney Covey, anything you think I've overlooked here today as it relates to this motion?
Judge, I'm very satisfied with the colloquy. I think just to make a record, I have just one other issue. If I may ask Mr. Brooks a quick question.
Go ahead.
Mr. Brooks, I know you talked about that there are some difficulties. I just want to make sure, are you still allowed to have access to your legal files?
So the legal files is something that I haven't been explained. I didn't know that there was conversations about the whole flash file thing. I haven't even heard anything about that. I really don't know how. Somebody maybe here can explain to me how that will work. So I'm kind of like trying to figure it out myself, actually.
Attorney Covey, it's my understanding, based on what you've said, I mean, you believe the institution will accept the external hard drives, obviously any paper that you send through regular mail, just not banker boxes or large boxes full of materials.
Yes. So if I were to send them a 40-page packet of materials with appellate rules of procedure and extension motion templates, I think any facility would allow that to be processed through, so long as I don't have clips or staples. As for, but they balked. My initial email, I don't have this memorized. I don't want to make a false statement, but my initial recollection when I first contacted that prison facility was to say that we were going to send them the files. I was told they would accept the file, but then when I stated, or when staff stated that it would be 5 bankers boxes, they put the brakes on that. And then there was some correspondence between their legal staff and my legal staff as to the best way to do this. We'll likely be buying some terabyte hard drives to put the materials on that to send to him. I don't know how much access you'll have to the library. I know in Wisconsin, you can go in almost every prison facility, unless you're in some kind of segregated status for a fight, for example, with another inmate, that you can make reservations to go to a computer library to review your legal documents. I also know that the time is quite heavily rationed. He's not going to have 8 hours at a time to look at these documents. So that will be a challenge for him.
I was just going to say that too. There's no law library, which I've never seen a jail or prison without a law library. So I don't know how that's going to work.
Do you have access to anything through a computer or online to access research material?
I have access to look at, I believe it's Westlaw, and those are tablet based. But even that is challenging.
I use a tablet based Lexis. It's a similar platform. it can be cumbersome unless you know how to switch to the natural language search engine and how to limit the jurisdictions and what you're looking at. But
Sure.
I think it's similar to what you had when you were in Waukesha, is that not?
No, Waukesha had Nexus, Lexus, or however you say it, Lexus, Nexus, or
Oh,
which is-
they're very similar. If you figured out Lexus, you can figure out Westlaw. In my humble opinion.
Judge, if I may add one thing.
Go ahead.
Mr. Brooks, I know that without going into the substance, I recall about a 2-hour meeting when we went over a large amount of case law together. What I'm happy to do is I can send you those copies of those cases that we discussed.
I appreciate that. Thank you.
Thank you.
Thank you. Mr. Attorney Basie, is there anything the state wants me to consider or any additional information from the state today?
You got it.
All right, then, as I indicated earlier, and I'll just go through some of the law that pertains to this issue in making my decision. A person convicted in Wisconsin of committing a crime has a constitutionally guaranteed right to appeal his or her conviction to the appellate courts. That's directly from the Wisconsin Constitution, Article 1, Section 21, and case law State versus Perry, 136, Wisconsin 2nd, 92, a 1987 case. The right to an appeal includes the right that the appeal be a meaningful one. An indigent defendant is constitutionally entitled to the appointment of counsel at public expense for the purpose of prosecuting his or her one and only appeal as of right from a criminal conviction. And I'm citing to or from State versus Thornton, and that again is 2002 Wisconsin Appellate 294. And that court was citing to the U.S. Supreme Court in Douglas versus California, 372 U.S. 353 from 1963. There's no dispute here today that Mr. Brooks is indigent. This court has noted previously, I've dealt with this issue with Mr. Brooks previously prior to trial, but a criminal defendant may waive his or her right to counsel in criminal trial court proceedings, provided the record reflects that the waiver is knowingly, intelligently, and voluntarily made, and that the defendant is competent to proceed pro se. That's a citation to State versus Klessig. Appellate or post-conviction counsel appointed by the state public defender may move to withdraw from representation of a client, and in determining the motion, the court shall consider whether the defendant waives the right to counsel, and that's Wisconsin Statute Rule 809.30 sub 4 sub C. As I indicated earlier, at the writing of Thornton, no Wisconsin appellate opinions address the requirements for effecting a valid waiver of appellate counsel. Thornton relied heavily on Oman versus McCoutry, which was, although a Wisconsin case at that point in time, it was before the 7th Circuit Court of Appeals. The citation for that is 130 F 3rd 809 from 1997. I did review that case as well. And from that case, the Thornton court stated and found that before a court may conclude that a criminal defendant has knowingly and voluntarily waived his or her right to counsel on direct appeal, it must satisfy itself that the defendant is aware, one, of the florist's rights, which I've talked about, that's the right to an appeal, to the assistance of counsel for the appeal, and to opt for a no merit report that was briefly mentioned previously. 2, the dangers and disadvantages of proceeding pro se, which this court has, I think, exhaustively gone through with Mr. Brooks. And 3, of the possibility that if appointed counsel is permitted to withdraw, successor counsel may not be appointed to represent the defendant in the appeal. We know from the letter from the State Public Defender's Office, they will not appoint successor counsel, and that's a citation to document 690, filed February 26 of 2025. This court is satisfied that Mr. Brooks is freely, voluntarily, and intelligently waiving his right to appellate counsel. He confirmed many of the same requirements, if you will, that I went through with him at the time of his waiver back on September 28th of 2022. I'm not going to read the entire excerpt into the record, but I am looking at the transcript, which is document 580 from that hearing, pages 75 through like 77. The court makes some findings that I believe are confirmed here today, and he said today he had a GED that may have been referenced as an HSED. I think they're very similar. Nonetheless, Mr. Brooks has a high school equivalency diploma or a general education diploma. He's been able to communicate very clearly with not only counsel, but with the court. He's done that efficiently and effectively. He did not have questions for the court today. Frankly, this procedure went much more smoothly than the procedure and the questioning and answers back in September of 2022. And so I'm just going to rely and incorporate herein by reference many of the findings or all of the findings I made back then, because nothing has been presented to this court that would dissuade it otherwise, that he's intelligent, he understands the dangers and disadvantages of proceeding on his own. He's made the request. He now knows the SPD's position. He indicated it doesn't change his mind. We've discussed many of the disadvantages and potential pitfalls of proceeding on his own. He's in an out-of-state facility. He does not have the same access as he does in Wisconsin. We have some wonderful offers by Attorney Covey to send him additional information. He's aware he needs to file for an extension because the current deadline in the Court of Appeals is June 3 of 2025. So I have met, and through the colloquy here today, the requirements of the Thornton case, and I'm satisfied that he's doing so, again, freely, voluntarily, and intelligently, and with an understanding of really the dangers and disadvantages and of his rights to an appeal and to appellate counsel. And for all of those reasons, the court will grant Attorney Covey's motion to withdraw. And from here on forward, the court will consider Mr. Brooks a pro se litigant. We will be able to communicate directly with him. I would like an order. I don't recall if you sent a proposed order in, but if you would do that, Attorney Covey, I will certainly review that, sign it, and then we will send that on to Mr. Brooks.
I'll get that done before the end of the day.
Thank you. Mr. Brooks, anything else from you today? Attorney Covey?
Judge, I will make a request. Generally, once I'm allowed to withdraw, I'm cut off from the e-filing. I would request that I have the opportunity to send Mr. Brooks all of these materials, that I can file a letter with the court saying that we have done so, make a record of that, and then at that point, perhaps I can be cut off from the e-file if the court so desires. If there is some kind of issue where the prison won't accept anything, for example, then we would be able to address that. I just want to make sure that he gets his materials before I truly end my representation on this case.
You're asking that I delay the approval until you've been able to pull everything off from the court file that you currently have access through as an e-filer.
I guess so. You can sign the order at any time. I don't, and oftentimes I'm kept on the e-filing system even after I've been withdrawn. It's just kind of a quirk of the e-filing system. So we can sign the order at any single time, but I would, as a friend or as a courtesy to the court, I could still draft an update letter letting the court know that these materials got sent out. I'm not trying to complicate it.
That's okay. My clerk is advising me that we can delay removing you even though I signed the order of discharge.
Thank you, Judge.
Any objection from the state?
No, Your Honor.
All right. Anything else from the state today?
No, Your Honor.
All right. Thank you, everyone. That does conclude the hearing today. For purposes of our live stream, we just not turn it off for about 30 seconds or a minute because there's a delay in the broadcast, and we want to make sure everyone gets there.
Thank you.
till the end. Thank you,
Thank you, Judge.
everyone. Good luck to you, Mr. Brooks.
Thank you. Good luck, sir.
Okay, let's get this straight. Attorney Covey has the highest level of certification that a public defender can have. The Court of Appeals gives no breaks or allowances for pro se defendants. They will not reassign a new counsel if he changes his mind later. He is not familiar with this new prison facility's capabilities when it comes to the law library. In fact, he says they do not even have one. He hasn't spoken with anyone there at the new facility about his access to the legal documents and the times he will have access to them. He has no idea how to file the proper documents to the appellate court. But yeah, he thinks representing himself is best. As always, Brooks is his own worst enemy. So let's go over what happened next.
Darrell Brooks was given an extension to January 7th to formally file his appeal in the Waukesha parade trial. Back in April, Brooks demanded that his appellate attorney withdraw from the case and insisted on representing himself on appeal. Judge Jennifer Darrell approved that request. According to a local newspaper, Brooks later asked for this latest extension, claiming his prison has been on lockdown due to an ongoing drug investigation and a change in leadership. He argued that these conditions made it extremely difficult for him to locate his case file, which his former attorney said had already been sent, and to confirm that it was received by his current facility. Brooks also claimed the lockdown had no clear end date and could continue into 2026. In response, the Court of Appeals asked both attorney Anthony Covey and the state to clarify the status of Brooks's case file and his access to it. Covey stated that the file was sent to Brooks's South Dakota prison in mid-May, and that prison officials confirmed Brooks had access to it by early June. The state backed this up with a sworn declaration from an associate warden at the prison, confirming the case file was received in May. The warden also outlined 4 lockdown periods since then: August 11th to 15th, August 27th to September 1st, September 16th to 17th, and October 3rd to 6th. According to the associate warden, when the prison was not on lockdown, Brooks had access to his hard drive containing legal materials, computers for typing legal documents, and Westlaw Correctional for legal research. Even during lockdowns, Brooks still had access to Westlaw through his personal tablet. The warden further stated that since receiving the case file, Brooks has not requested access to the hard drive or computers to prepare court filings as of late November. Based on this information, the state asked the Court of Appeals to deny Brooks's request for another extension, or, at most, grant one final and shorter extension. It's worth noting that Brooks's notice of appeal was originally due on January 29, 2024, and he has now requested 11 extensions. The Court of Appeals ultimately granted him one final extension, setting a firm deadline of January 7, 2026, and made it clear that no further extensions will be granted.
Darrell Brooks' response was posted to the appellate docket on January 8, 2026. It was a letter dated December 23, 2025, postmarked January 2, 2026. In the letter, Brooks claims the warden provided false statements regarding his access to his legal documents. He seeks another extension as well as an evidentiary hearing in the matter. The appellate court has finally responded one last time to Darrell Brooks. Decision date, January 27, 2026. It is ordered that the motion for an extension of the time to file a notice of appeal or post-conviction motion and for an evidentiary hearing is denied. The Wisconsin Court of Appeals officially denied Brooks' request for another extension, stating he failed to establish good cause to bypass the January deadline, effectively closing the door on his appeal rights. So, there you have it. He is locked down for life. He will die in prison. Before you go, I thought it may be a good idea to check out this South Dakota facility he is in as of the release of this video. The current Sioux Falls Penitentiary in South Dakota is 144 years old and is commonly referred to as the Hill. I searched YouTube for videos on the facility. The following are clips I found notable. You may also want to pay attention to the dates of each broadcast.
A year ago this month, Governor Kristi Noem fired top officials at the state penitentiary in Sioux Falls and replaced the Secretary of Corrections after getting an anonymous complaint that included allegations of sexual harassment, nepotism, poor pay, and bad equipment. 3 months ago, a review of the Department of Corrections was complete and indicated the need for better safety, less turnover, and the need to deal with issues of harassment and a hostile work environment.
Brandon Balsavage started working as a correctional officer at the state penitentiary in 2019.
Because I've always had a liking to law enforcement or corrections.
6 months into the job, an inmate attacked him.
An inmate grabbed me by the neck and started stabbing me in the face, right here, closer to my artery right here. If it would have been a ½ inch down or a quarter inch down, I would be dead right now.
Balsavage says it was the prison's lack of following basic safety protocol that put him in this situation in the first place.
But how this happened, I was going up, open the door. The doors are supposed to be secure. They were not.
Balsavage's attacker, Alan Janis, who is serving a 20-year sentence for armed robbery, pleaded guilty to attempted murder in the incident and was sentenced to another 50 years. Janis had a history of violence behind bars. In 2014, Janis pleaded guilty to sliming or assault by an inmate.
Nothing changed after that day. With the doors being closed, they enforced that for about 2 months, and then to this day, those doors are still open.
Several people in leadership positions were ousted. State Penitentiary Warden Darren Young was replaced by Dan Sullivan. But Balsavage says one of the hot-button issues, sexual harassment, something Warden Young was accused of, is still happening. Balsavage claims that instead of reporting it, officers in charge just move people to different areas of the prison. Eric Olala is executive director of the South Dakota State Employees Association, which is a voluntary association for state workers. Balsavage says correctional officers are not getting self-defense training.
And this year, nobody got that defensive tactic training. Even the new people coming in didn't get the defensive tactics because they didn't want to put on the class.
The employees are at their wits' end. Their conditions are getting so restrictive. The system is frayed, and it's about ready to break. Lives are at stake.
At the penitentiary in Sioux Falls, more than 22% of positions are going unfilled, and the turnover rate is nearly 30%. Balsavage says shortages have resulted in certain security stations, known as pods, not being staffed.
There has been multiple occasions where they have been unmanned for an entire night. The thing that controls the whole unit has been unmanned for an entire night.
A correctional officer who works at the South Dakota State Penitentiary says that he thinks what the Secretary of Corrections describes as a disturbance at the facility yesterday could repeat.
Do you think it's going to happen again sometime soon?
If the phones stay off and the tablets stay off, yeah. But I think the next time it's going to happen, it's going to be hours.
Schlegel says an inmate was refusing to go back to his cell because he was protesting a lack of access to tablets and phones. The inmate was getting cuffed, and that's when, according to Schlegel, the assault happened. A corrections officer tells us the prison is still woefully understaffed.
KELOLAND's Tom Hansen shows us tonight staffing has been an ongoing challenge for the state's only maximum security prison for men.
Staffing inside South Dakota's correctional facilities was one of the first things Corrections Secretary Kelly Wasco focused on when she arrived 2 years ago. Recently, she told state lawmakers activities in the prison are sometimes canceled because of a lack of staff. The state is actively recruiting to fill positions. 8 years ago, Terry Liggins got out of federal prison. He now works to help ex-prisoners adjust to life outside and lead productive lives. He says a staff shortage is a recipe for confrontation because of stress. Governor Kristi Noem says the state has invested heavily in staffing, training, and equipment for correctional officers.
The state prison system in South Dakota is seeing its share of violence. There are currently more than 100 court cases involving prison inmates in the hands of the Attorney General's office. The South Dakota Attorney General Marty Jackley says the problems are on his radar, and his office is sending a message to inmates that violence won't be tolerated.
A judge recently sentenced 2 inmates convicted of attempting to murder a correctional officer inside the state penitentiary. The judge said the officer was lucky to be alive after receiving more than 70 blows, many to his head. The judge sentenced Kyle Jones to an additional 50 years and Lester Monroe to 35. Jones smiled and smirked at the judge and said he wasn't sorry for what he did. He told the judge there will be more violence until inmates are treated with, in his words, more respect. Right now, the Attorney General's office has 117 criminal cases pending out of the state penitentiary in Sioux Falls. Jackley says he is taking a no-tolerance position and will vigorously prosecute each and every case. Jackley says Jones' 50-year sentence doesn't even start until 2063, so it is basically a life sentence.
And the South Dakota State Penitentiary opened up way back in 1881, before South Dakota was even a state.
Our chief photographer, Kevin Kiergaard, and I spent more than an hour inside the penitentiary this morning with Wasco showing us examples of how a century's wear and tear is impacting the safety of inmates and staff today. In recent public comments, South Dakota Governor Larry Roden has made clear his concerns about this aging facility. The penitentiary was built to house 400 inmates, but this morning's count was nearly double that, 784. They're all together inside these walls, with most inmates double bunked. There have been several instances of triple bunking in recent history. We had the opportunity to look inside cells, but we were asked not to shoot video. Those numbers and this lack of space would bring considerable concern in any facility, no matter the age or condition. But this one has seen better days.
And the walls are crumbling, the foundation is displaced. We don't have adequate cell space for our offenders. We don't have adequate showers for our offenders. And there's absolutely no treatment space without them having to travel across an outdoors area.
Secretary of Corrections Kelly Wasco and Director of Prisons Amber Perelia, who is interim warden at the penitentiary, both accompanied us on today's tour. This hallway where inmates are transported had a prominent place on the tour, with Wasco playing the role of an inmate and Perelia and DOC Major Cody Hansen acting as officers accompanying the offender. You can see the challenges.
So we would come this way. The inmate would have to step over first. And then as she's stepping over, one of us would have to step over just so we keep continuous contact. And we would wait. And then we would go on our way.
You might notice that this piping isn't exactly in the best condition. There's a reason for that.
They're dented because so many times we've used restraints over here. And just the usage over time, they get dented from the restraints for how many inmates will go back and forth.
Back when this facility opened, the Civil War's end was recent history. And Wasco says attitudes have changed since then.
We don't have the type of inmates in 2025 that we had in 1881. The people in 1881 were repenting their crimes and their sins. Today we have a much more brazen type of offender. And so our staff are walking by and often being fluid assaulted or having objects from the cell thrown at them and hit them.
To be fluid assaulted might include spit or urine launched at staff.
We have our backs against the wall. It's a miracle we haven't been sued as a state to this point. And so we're going to get this fixed.
Among the stops was this group shower, which the DOC highlights as problematic.
The crumbling of the concrete, the rusting of all of the metal, the ductwork is falling apart and eroding.
But the infrastructure of this 40-head group shower isn't the only possible concern.
There's issues for having staff. There's one way in and one way out. If you have 40 offenders underneath the shower heads and 40 offenders on deck, and you have 2 staff down there with 1 stairwell to get out.
DOC Secretary Kelly Wasco says this kind of shower is a relic of the past, and this facility has seen well over a century of history.
You won't see those types of showers being reconstructed in modern facilities today.
This video, along with what we saw when our camera had to be put away, are evidence of this prison's aging condition. Wasco says this penitentiary falls short in helping its inmates look to the future.
There's no treatment space. There's some classroom space that's across the yard, but that's reserved for education, GED. But when you don't have the ability to treat in environments like therapeutic communities, whether it's for substance use disorders or cognitive behavioral therapies, we create an environment that's dark, it's small, it's enclosed, it doesn't promote pro-socialization.
In Sioux Falls, Dan Santella.
The South Dakota State Penitentiary and nearby Jameson Annex are on lockdown tonight.
The State Department of Corrections confirms that it started at 7:30 this morning. And while the DOC hasn't released the reason behind the lockdown, the department says that it's not because of an assault or disturbance.
The DOC declined an interview request today. This current lockdown has us thinking back to the last publicly announced lockdown. As he tracks the legislation that would appropriate money to build a new men's prison, KELOLAND's Dan Santella looks at what the DOC had to say about September's lockdown.
It's a frigid, frozen evening outside the South Dakota State Penitentiary, where inside the inmates are once again on lockdown. The last lockdown began on September 15th and continued until October 2nd. Officials said it was done as a, quote, proactive security measure to implement a full campus search and seizure for dangerous contraband. The initial release said handmade weapons and electronics were discovered. Later in October, the DOC told the legislature's Government Operations and Audit Committee about contraband found during the Sioux Falls lockdown. Officers allegedly discovered sharp items, including tweezers, a homemade tattoo gun, and tools.
Availability of illegal drugs behind prison walls in South Dakota is in the spotlight this week and is raising a lot of questions.
South Dakota Attorney General Marty Jackley says overdoses were likely responsible for 2 recent prison deaths. One inmate was discovered unresponsive at the state pen, and another was found at the nearby Jameson Annex.
Minnehaha County Sheriff Mike Milstead and state lawmakers Jamie Smith and Greg Jamieson are all part of Project Prison Reset's task force, a group examining where to recommend building a replacement for the state penitentiary in Sioux Falls.
Let's just say we're at the new prison and these inmates are still addicted to drugs but are receiving proper treatment. Maybe there'll be less pressure from the outside to get drugs in because that inmate isn't after it so bad.
But drugs are making their way behind these walls.
We have 62 open criminal files in the penitentiary right now. A majority of those are controlled substance related, and certainly that's a concern.
Milstead points out how someone walking or driving by the current penitentiary has the opportunity to simply throw something over the prison wall situated right next to North Drive.
It's not unusual for contraband to go over the walls at the state prison.
He also brings up in-person visits, which are not allowed at the Minnehaha County Jail.
Quite frankly, as I said, if they continue to have contact visits, that's the weakest link. It's nice to have a contact visit. Sure. We have found, though, that our video visitation, we have no complaints.
A new facility could bring with it significant change, but contraband is not a simple problem.
Is it going to make it all better right away? No, there's many sophisticated systems that inmates have in order to do that.
Current prison is antiquated and doesn't have the space, doesn't have the resources to take care of those issues that are crystal clear to me.
In Sioux Falls, Dan Santella.
This week, the Department of Criminal Investigation announced they're looking into assaults at the South Dakota State Penitentiary, and the Department of Corrections announced they busted a drug smuggling ring. All of this adding to the ongoing concerns about what is going on inside prison walls.
This week alone, protests for better inmate treatment in response to inmate deaths and a prayer walk took place. The ongoing concerns about what goes on behind prison walls certainly extends to those who have a loved one serving time. For them, the most recent events fuel their worry even more.
Megan McGilkey is from North Dakota, but she makes the drive to Sioux Falls whenever she can. Her boyfriend is behind bars.
A lot of phone calls. That's kind of basically what the relationship consists of, is a lot of conversations, especially with being so far.
McGilkey says her boyfriend tells her about what he sees on a daily basis, even outside of the violence and unrest. He has a job in the kitchen and has relayed stories of mold, cockroaches, and rats. He also described to her poor treatment and delayed reactions to treating inmates who need health care or mental health resources.
I mean, I've heard that some other guys have waited up to 10 months to see any type of mental health care. Same thing with medical care.
South Dakota Attorney General Marty Jackley says they're getting to the bottom of what's happening inside the penitentiary, but can only do so much. While the DOC independently makes their own decisions about everyday operations and administrative actions, DCI is making sure inmates are held accountable for further crimes.
Whether it be bringing in a shank into the prison, bringing in controlled substances, getting into fights, that message is heard loud and clear that you've got to follow the rules, and when you don't, you have an attorney general that's going to hold you to the letter of the law when it comes to especially dangerous conduct that's harming either guards or other inmates.
24 inmates at the South Dakota State Penitentiary facing assault and riot charges now following a May 27th fight. The Attorney General's announcement yesterday alleges that those inmates are tied to 9 different gangs.
The Boys or the TBZs, the Red Brotherhood, which is RBH, the Gangster Disciplines, the GDs, the Bloods, the Crips, the Northside Mafia, the Warlords, the East River Skins, and the Vice Lords.
The May 27th unrest, now legally classified as a riot, appeared to be coordinated, according to investigators.
The charges include 24 inmates.
A Department of Justice report lists the top gang activities behind bars as intimidation, trafficking drugs, assault, extortion, or abusing weak inmates, and for members to protect each other. A source tells me gang recruitment at the South Dakota State Penitentiary is a real thing. Those I spoke to today with local prison gang knowledge are thankful for the absence of white supremacist gangs in our prisons. In Sioux Falls, Beth Warden, Dakota News Now.
Well, after months of discussion, the prison task force has finally made its recommendation for a new men's prison to be built in Sioux Falls. However, the South Dakota Department of Corrections wants to continue to show the public why a new prison is needed. And today, KELOLAND's Lauren Solik was one of 8 journalists allowed behind the prison walls for a tour of areas that we haven't seen in recent memory.
In February, KELOLAND News was invited on an exclusive tour of the South Dakota State Penitentiary. However, our news crew was only allowed to film in certain areas of the prison. Today, myself and 7 other journalists were given a tour that was similar to that given to the members of the Project Prison Reset Task Force. We weren't allowed to have cameras or recording devices on the tour. However, photos were taken for us as we walked through the prison. In this photo, you can see our tour lined up in a tight hallway just outside a cell block on the 5th level of East Hall.
It's all straight up. There's no elevators. It's all steps. And as I said on the tour, the trays, their meal trays, get carried up all 5 flights by our staff. The medication boxes to deliver meds cell to cell, they all get carried up those stairs.
This photo was taken looking down one side of the 5th floor, where there are 20 cells with each holding 2 inmates. We were also taken to one of the shower rooms where there might be 120 inmates at once, 60 showering and 60 waiting, but only 2 correctional officers. We were told the steam from the showers also often block the view of the security cameras. We also saw the basement rec area that includes a gym and weight room. One major concern for Wasco in this area is that the windows, like the one you see here, are made of regular glass that can easily be broken by inmates. As we walked through the prison and its work areas, Wasco wanted us to keep in mind one sentiment she shared with us both before and after the tour.
The benefit was for everybody to see what we've been talking about, to see what the legislators saw when we took them through. And as I said, you know what, it's not going to get any worse than it is. The only thing left for it to do is to fall over.
In Sioux Falls, Lauren Solik, KELOLAND News.
Monday was the last day for Kelly Wasco serving as the Secretary of Corrections for the state of South Dakota.
The same day, the governor's office announced Nick Lamb will serve as the new DOC secretary starting in mid-November. Beth Warden looks into Lamb's history and talks to a previous inmate under his watch.
Cole Lohman has a new lease on life and says he's learned his lesson while serving time for theft in the South Dakota State Penitentiary and at Fort Dodge and Rockwell prisons in Iowa. He says the 2 prison systems are wildly different.
Well, South Dakota was traumatic more than it was helpful. You're just kind of forced to be in that tiny cell. You know, like I was there for a theft charge, and I was put on the hill.
He didn't see drugs in the Iowa prisons, but did at the South Dakota State Pen.
Anything that I wanted to get on the streets, I could have readily gotten on the Hill just as easily.
The DOC under Lamb's leadership. A recent report from the Iowa DOC showed free video calls for inmates and tablets for therapy and programming. Governor Roden's announcement says that Lamb has over 30 years of experience in a prison setting, along with military experience. Lamb also has a master's degree in psychology.
Henry Carlson Construction and J.E. Dunn Construction hosted a groundbreaking ceremony April 22, 2026, for the new South Dakota Correctional Facility in Sioux Falls, which will replace the current 145-year-old facility. The new prison will be built on industrial land 3 miles from the current site. According to the plans, housing will be spread across 4 separate buildings containing a total of 1,188 cell beds and 300 dorm beds. The new facility will offer 40 square feet of day room space per inmate, exceeding the 35 square foot ratio required in American Correctional Association standards. The new prison will also triple the vocational training space offered at the current state penitentiary and offer increased space for faith-based rehabilitation. It is targeted for completion in 2029. Brooks isn't the only high-profile offender located in South Dakota. Charlie Adelson was also recently moved there following extortion threats. He is a former South Florida periodontist serving a life sentence without parole for orchestrating the 2014 murder for hire of his former brother-in-law, Florida State University law professor Dan Markell. You may be asking, what will we cover next? Well, believe it or not, I still have a few videos left on Brooks. I want to cover key moments in his pretrial days to round out the trial playlist. And since going through his trial so thoroughly, I actually found more humorous clips that I think deserve their own video. So if you are here just for this case, don't go anywhere. We're not done yet. Stay safe, everyone, and we will see you next time.
Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.